Young Thug might have a chance to get his case thrown out. Welcome to the Mr. Wilson's Got a Headache podcast. I'm your host, Dennis the Menace. If you've been keeping up with the Young Thug case, you remember an incident with Judge Glanville and Young Thug's attorney. Check this out.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information and belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
Pretty much what they were saying is that there was a closed-door meeting that they call an ex parte meeting. And in that meeting, DA was present, but the prosecution or Young Thug's lawyers didn't even know about the meeting. According to most legal experts, they should have been made aware, and they shouldn't have had any conversation until the defense attorneys were present. As a result, Judge Glanville decided to do this.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present.
And you haven't answered my question yet.
I'm not
How
going
did
to
you
answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is why wasn't I there?
Why, sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering.
And then walked in Ashley Merchant, who's the president of some organizations that defend lawyers against judges in these type of situations. Ashley Merchant is the one who's dealing with the Fonnie Willis case in the same county.
If the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
So Young Thug's lawyers filed some appeals requesting that the case will be moved to another judge. The question is, why is this so important and why did I want to talk about it today? Before we get to that, let's listen to a lawyer's take on it.
Going to the law, the legal framework for what a recusal requires. There are 3 criteria that needs to happen. Those being the motion needs to be timely, needs to be supported by an affidavit, and the facts alleged need to show that a recusal might be warranted. Now, to the first 2 parts, Judge Glanville himself said that this is timely. When the defense found an issue, they brought it up. The second part, he said that there's an affidavit that was filed. Good. But the reason why Judge Glanville himself said that he's denying the recusal is because he argued that the facts alleged did not warrant a recusal, that they did not meet that threshold. However, he ultimately passed this case on to another judge, and this is the judge's analysis analysis and discussion. It's just a quick, I wouldn't even call it 2 pages. I'd call it a page and a half, if that. And the judge does start off by saying, as previously announced on the record, this motion was timely and supported by an affidavit. Already got that. But moving on to the next part, the court kind of pauses and says, you know what, it's worth noting, and I'm just quoting here, that this court agrees generally with Judge Glanville's assessment of the proprietary of the meeting, that ex parte meeting, saying, okay, that's okay to happen. While the meeting could have and perhaps should have taken place in open court, kind of giving that option there, nothing about the fact of this meeting or substance discussed was inherently improper. However, and this is the big however, in his order denying defendant Kendrick's motion and in the process of making a record on July 1st, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Just going to keep going through here. While, and I'm quoting here, may be appropriate for judges to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. As we saw in Judge Glanville's recitation of why he was not recusing himself, he was, let's just say he was definitely a little hostile.
Judge Glanville was definitely in his feelings a little bit when he was talking to the other lawyer. So today, another judge decided that the case should be tried by someone else. Now, before this judgment came through, about a month ago, I did a video on this on my YouTube channel. Go check that one out. But a lot of legal experts were saying that if the judge was removed, then they may have grounds to file a mistrial. So if that happens, it looks like Young Thug and his homies might be back on the street. Young Thug has been involved in the most expensive case in the history of Fulton County, according to most legal experts. He just dropping money. Guess he got it like that. If you're interested in having updates on this, make sure you follow me. You subscribe to the channel. Leave a comment. I definitely want to hear what you have to say about it. Like, share, comment, and subscribe. I'll see you on the next video.